I am Rebecca Dobbs-Bush. John, Larry, and Andrew are on this with me, and they are in our finance group, lending group. They work a lot with banks and finance and lending issues for other companies, and so they are really like the stars right now in helping you get access to this funding. I am a partner in our labor and employment practice group. I focus on employment rules and tax, ERISA, all of those fun things, compensation planning. So I come into play when I'm helping people take all of this into account in designing their compensation packages. And with that in mind, I'm going to turn it over to John so he can give a brief introduction and give you some ideas on what we will be covering.
Thank you, Rebecca, and thank you everyone for joining us. My name is John Tansel. I've been practicing, I hate to admit it, almost 40 years now, and I'm co-chair of the financial services group here in the firm. We're in scary times, and one of the reasons that this firm wanted to do this seminar is to try to get information out to you about how to keep your business going, keep it viable, keep your employees working. So what we're going to do today is engage in a high-level discussion on what this new CARES Act has put out there that's available for us. Having said that, I have to warn you that the Small Business Administration has yet to put out guidelines. I've talked to so many banks over the last several days who are scrambling to figure out what the process is that's going to work for all of you. They're expecting a tsunami of applications under this SBA program. So a couple of things before we get started on the webinar. I want to take a moment just to give you some practical advice. When you go talk to your bankers about this, they are overwhelmed, and I've had several bankers say the only people we're going to give an SBA loan to under this program that Andrew's going to be speaking about are those who are current customers of the bank. So the first thing you should do when you get off of this webinar is call your banker and say, I want in this program. I need to be in this program. That's the very first step, and that's very important. If you take nothing else away from the webinar, take that away. Secondly, you need to start gathering information that they're going to want to see. I'm going to talk about getting loan deferrals later, but even with this SBA program, they're going to want to see your organizational documents, whether it's your articles of incorporation or your operating agreement. So get that. Get verification of your payroll, because how much you can get under these programs will be driven by what your payroll has been. Start getting documentation about how much you're paying in rent, how much you're paying in a mortgage payment. Get your utility bills put together. Those are things that you'll hear later that you'll be able to get reimbursed for if we do all this correctly. And if you listen to us, you will do it all correctly and you will get reimbursed. Get your financial statements together. They don't have to be audited, but get your 1231 statements together, get your monthly statements going forward for Q1, so that when you sit down and talk to your banker, your goal is to make it as easy for that person so that he or she can make that decision quickly. So having said all of that, what we're going to do here, well, I'm sorry, I want to back up. The SBA is not sure when. There was some talk they could have guidelines out to banks today. I've not yet seen anything that indicates that that has occurred. Other people are hoping, you probably heard over the weekend, that they wanted to get this program up and running by Friday. With every hour that goes by, that becomes less and less likely. But my goal is for you to be ready when that program is up, to walk into the office, sit down with your banker, be on their list, and say, here's my stuff. There is no application yet online, so don't go look for that. If you're going to fill out anything, the SBA has a Form 1919. That's 1919, and it's just the borrower information form. That's probably a good place to start if you want to get somebody cranking on that one. So with all of that as background, we're going to talk about the programs that are available under the CARES Act. Andrew Podgorny will start talking about the payroll protection program and about the tax credit provisions. Then Larry Tomlin will talk about the gear up that the Federal Reserve is doing. They've been in the Wall Street a lot recently about the programs that they're going to start up with, going all the way back to the Great Recession in 2008 and the TARP programs that they use for the banks. They're going to kind of take a page out of that playbook for direct lending to certain larger businesses. Then Rebecca will wrap it up in, I'm sure, extraordinary fashion, talking about the expanded unemployment benefits, some loosening of the rules for retirement accounts, and then the Section 139 qualified disaster payments. So Andrew, tell them how they get the payroll Paycheck Protection Program payments.
Okay,
Hi, John. Rebecca, go ahead.
Sorry, Andrew. Hold on. And I ask all of you to bear with us because, as you know, we're all supposed to be self-isolating. So the four of us are in a different location right now. And I am sharing this. So I transitioned my keyboard to Andrew at this point so he can control the PowerPoint. One thing I want to mention too, just to clarify before Andrew takes over, is that, in the beginning, the stuff that Andrew's going to talk about are for businesses with less than 500 employees, but don't despair if you're not in that category because, Larry's going to pick up on the stuff that covers businesses that are larger, and the stuff I'm going to cover applies to companies as a whole. So that, don't despair if you're not covered by the beginning. Thanks, Andrew. I'm transferring control right now, if it allows me in a second.
All right, sounds good.
There you go.
All right, well, welcome everyone and good afternoon. Thanks for joining us. As John mentioned, I'm gonna kind of give a high-level overview and some considerations regarding the Payroll Protection Program. This program was enacted last Friday under the CARES Act, and it's kind of geared towards providing small businesses interruption loans due to the COVID-19 crisis. Kind of the big issue with the SBA is generally there's pretty large restrictions on who can apply for the loans and who qualifies as a small business. One of the things that this program does is it expands the eligibility to include most employers that have not more than 500 employees, or in some cases, it might be more than 500 employees if your NIC code is larger than that based on the current SBA guidelines. Two important points that we wanted to mention on the 500 employee threshold. One is that the SBA, they have pretty broad rules with respect to affiliates of companies. The SBA looks to kind of a control and get a control test with determining who is an affiliate of somebody. So if another company controls a second company, those two would be affiliates, and the employees would be aggregated together for purposes of calculating this threshold. Similarly, the same thing can happen if, for example, one individual owns two separate companies and has power to control both of those. The employees of both companies would be aggregated there. So it's something to consider when looking at your eligibility for this, is to consider any other affiliated entities under the SBA's guidelines.
Andrew, this is John. That's a great point, and I know we have several clients that we've had discussions with between in the last several days, because they've got like their developers and they have a bunch of different companies that are separate legal entities, and that would all be aggregated under this program, unfortunately.
Correct. And the second point on the employee threshold is another question we got from a lot of our clients is, all right, well, how do we calculate that number of employees? Can we, I guess, for lack of a better word, let some people go to get under this 500 threshold and still count as qualifying. Our interpretation of the current SBA rules would be no, that cannot happen. What the SBA is going to look at for classifying or counting your number of employees is they include all full-time, part-time, and other employees that are hired on a other basis. So this may also include, for example, independent contractors that have a sufficient employment relationship with the applicant. And also, what we're going to be looking at in terms of calculation and timing is the average number of employees that an applicant has based on the number of employees for each pay period in the preceding 12 calendar months. So we really have a bit of a one-year look-back period to determine if you qualify under this 500 employee threshold.
Andrew, let's circle back for a minute on the affiliation rules. One of the exceptions that I want you to talk about is the franchises.
Correct. I apologize for skipping over that. But yeah, as we indicated on the slides, some entities, for some entities, the SBA under the Paycheck Protection Program, they have waived the affiliate rules. This is going to primarily apply to people with NICS code 72, which are businesses in the accommodation and food services industry. And then kind of on a related note to those code 72 organizations is also when counting the 500 employees, if you have been assigned a franchise identification code by the SBA, you can count those on a per location basis versus aggregating them with other franchisees. Apologize, I think I skipped over a slide here. All right, next we just want to talk a little bit about what a lender is going to look at. This process, if you're familiar with typical SBA loans, as compared to those, this is much more streamlined. The loans are actually going to be made at the financial institution level rather than being made directly by the SBA. So a lender, when they receive your application, in addition to some of the other items that John mentioned, is the two main requirements they're going to look at is whether the business was in operation as of February 15th, and also whether it had employees or independent contractors that it paid. This kind of goes to John's point earlier about starting to compile some of your payroll-related records in anticipation of applying for this program once applications become available. The applicant's also going to just need to make a good faith certification. This is just going to be as to the need for the loan funds, and that you will use them for the permissible purposes under the program, and that you don't have any type of duplicative application or funds already received. Some of the other typical SBA requirements that are waived in connection with this program are that there's no requirement to satisfy the credit elsewhere test under the SBA rules, and also there's no requirement for personal guarantees or collateral.
And Andrew, this is Rebecca. If I can jump in real quick on that last point, because I think that is the hugest. Hello? If I can jump in on that last point, because I think that's one of the hugest points on this. You don't have to split back, but the no personal guarantees and the no collateral, that's where, this week has been fun for me, and although it just started, because for a couple of weeks being in labor and employment, all the calls were about how we could how you were allowed to cut people's salary, how to handle layoffs and all of these things. But now we get to talk about no, this really does apply to you. And I get to feel a little bit like the Publisher Clearinghouse guy knocking on the door saying, no, you really can't have this check, because you don't have to have a declining business. You don't have to have, all of those things going on. And I also don't understand why you wouldn't take this if you're eligible, because with no personal guarantees and no collateral, why would you not want to transfer, why would you use your existing lines of credit right now? That makes no sense to me because, if you're, especially in the category where you have to personally guarantee business loans or put up collateral, like why would you not use this money instead?
Rebecca, this is John. I completely agree, but I want to circle back also. That's why it's so important when you get your documentation together, and Andrew's going to go later talk about how do you get forgiven, because this isn't guaranteed. There's nothing out there. The part that's not forgiven is not going to help the bank unless we have the right documentation. So just keep pushing that idea with your people. Go ahead, Andrew.
All right. Thanks, John. All right.
One other point I want to mention, Andrew, is that for this, I don't know if the eligibility, if you address that 501c3s can qualify as well. You don't have to just be a for-profit business.
Correct. That's also, in addition to that, the expansion also would apply to individuals operating as a sole proprietor or independent contractors as well. Moving on to the important question is, well, how much money can I get under this program? The general basic test is 2.5 times your average total monthly payrolls during the prior year, not to exceed $10 million. And this kind of goes to the overall theme of this program is to, have the payroll cost essentially paid for by the government, so that you can keep employees on payroll and keep their salaries at pre-COVID-19 levels. There are a couple of special rules for employers if you are not in business in 2019 and certain seasonal employers as well. A couple of things on the calculation of the amount here. I have that the monthly amount is going to be 2.5 times your payroll costs. The program does provide a specific definition of payroll costs. It's pretty broad, but a couple of important things that it does include or exclude are compensation to any individual employee that's in excess of an annual salary of $100,000 as prorated for the period. And then it also excludes some taxes specifically related to payroll tax and income tax as well. And then if you're eligible for any credits under parts 1 and 2 of the coronavirus relief bills for sick leave or family leave wages, for which you can get a tax credit, those costs would also be excluded from this definition. So you can't just look at what exactly you pay. There's a little bit of a calculus that needs to be taken into account once you've compiled your records to see what was actually paid during the past year. Under the program, the use of program funds are limited to these categories I've listed here on the screen. Principally, these are your payroll costs, insurance, other commissions and compensation to employees, and then also rent and mortgage interest, as well as utility payments.
Andrew, I have a question came through that I think affects some people on the, some more people on the webinar in terms of, what if I already applied for one of the existing SBA loans? And I can't recall if that's in your next couple slides. So if it is, just say so. But if not, I wanted to ask if you could address it right away.
Right. Yeah, I'd be happy to. And it depends on what type of SBA loan you applied for. We'll talk about, we have a slide on this a little bit later, but there's a special loan program that the SBA has for disaster loans. So if you have already applied for a disaster loan for the same purpose, you can't also receive a loan for the same purpose under this Paycheck Protection Program. With that being said, if it is a disaster loan for a different purpose, the Act does allow you to essentially refinance that through the Paycheck Protection Program so that you can still get money for your existing payroll costs as affected by the COVID-19 crisis. Next is the loan forgiveness part. So as we mentioned, the amount of the loan that you're taking out can up to be 100% of that can be forgiven through payment of certain expenses. How this is going to work is starting on the date of the loan origination and continuing for 8 weeks, any payroll-related expenses that are incurred and paid by the applicant are eligible to be applied for loan forgiveness under this loan. So this goes to our point earlier about making sure you have appropriate documentation for your payroll costs as well as utilities and rent, so that you can submit these documentations after this 8-week period to your lender to get loan forgiveness. As we have on here, the amount of the forgiveness can't exceed the principal amount of the financing, but you can get up to that 100% level based on the costs that you incurred during this 8-week period. What are the expenses that are eligible for loan forgiveness include payroll costs, payments on interest for mortgage obligations, as well as certain payments on rent obligations, and also utility payments, for example, for electricity, gas, internet, telephone. For those, it has to be with respect to a service or obligation that's already in existence and not a new one.
Andrew, I have two questions for you to interrupt. So one is the time frame. In determining loan eligibility, you talk about 2.5 times the average monthly payroll cost. And we have a question of clarification of the period that the payroll is being averaged over.
For purposes of determining the maximum loan amount?
Right.
So for calculating the...
I know there's separate rules for brand new businesses that don't have the prior period, but my understanding is that it's of several months in 2019. Is that yours as well?
Right. So the calculation for the loan amount, you're going to look back at the monthly payroll over the 1-year period prior to when the loan's made.
Okay. And the hiring back of people, it can be new employees. It doesn't have to be the same employees, right?
Correct.
The curing your lowered payroll amount. Sorry, I'm facilitating questions, so I'm not trying to get me.
Oh, no problem. It helps. Well, let's go to that then. So Rebecca is kind of alluding to, and as we have here on the slide, the amount that you can receive for loan forgiveness. So, for example, if you have $10,000 worth of incurred expenses during this 8-week period, this $10,000 amount is subject to a potential reduction in the event there are reductions to the number of employees or the amount of compensation that these employees are paid. In terms of reduction in employees, we've had a few questions from clients on how this is calculated, and what they're going to look at is the average number of full-time equivalent employees per month during the covered period as compared to an earlier period. There's 2 possible earlier periods that the borrower can elect, but it's going to be compared to one of those 2 periods. And I just want to emphasize that it's based on here, at least, full-time equivalent employees. So that may give you a little bit more flexibility in terms of avoiding any reductions in employees.
Right. I've been explaining it as it's payroll amounts, they don't look at who the amounts are going to. They're just carrying, what you're paying, and that it's not highly compensated. It's not all going, in excess of 100,000. The
Correct.
Other question I had, one of them I can answer, I think, because the question was, our traditional SBA limits, revenue limits, those kind of things waived. And my understanding is yes. Is that correct?
You be more specific? Or
The traditional limits in terms of your revenues can't exceed X amount in order to qualify for SBA loans, and those type of things are disregarded for purposes of this Payroll Act.
right,
Payroll
correct. I think
Protection Program.
correct, and I think what that's referring to is under SBA small business classifications, depending on the industry, your primary industry, you can either be classified based on number of employees or amount of receipts. And so here, what we're really looking at based on the new expansion of eligibility is just looking at the number of employees not being more than 500 and not the traditional gross receipts test that
Okay, and to continue my theme of being a pain in your behind, because I'm representing the questions of 700 people, can you also clarify if, and it's a question I had as well, and in clarification, so maybe the answer's not out yet, but how, in that head count, do we know how non-U.S. companies, affiliated non-U.S. companies are counted? For example, if a Canadian company has a small operation in the U.S., do they still get this? Or, you know, if there's a European company with a small U.S. operation, are they still qualified? Do you know that answer?
Under the SBA, and obviously this is subject to if the SBA has maybe some looser regulations that they set out for their program, but generally speaking, the affiliate rules apply to any domestic or foreign affiliates.
Okay, so that means that if you are affiliated with a larger non-U.S. company, you would not qualify, right?
Correct.
Unless they change the rules and clarify. Got it.
Correct. Yeah, and I mean, you could still be affiliated with them as long as you're not at that 500, over that 500 employee threshold.
Rebecca, that's probably going to be something that's going to be
employees.
in the guidance that comes out later this week, or hopefully this week from the SBA.
Right. All right. Well, going back to the loan forgiveness piece, and as I mentioned, there's a possible reduction based on the number of employees. There's a second potential reduction based on compensation, and how that is calculated is, you know, they look at the total wages as paid to employees during this covered period, which is the 8-week period following loan origination, and any reductions in excess of 25% that was paid to the employee during the most recent full quarter is subject to reduction. And this is based on an employee-by-employee basis, so it's not based on the 25% of your aggregate payroll. You need to look at whether Bob Smith, his payroll was decreased by 25% compared to the last full quarter. One other important point to mention, this reduction based on compensation rule, this only applies with respect to employees who did not receive during any pay period in 2019 annualized wages that exceed $100,000. So for a lot of employees, this rule is probably going to be inapplicable for them. And then as Rebecca kind of had indicated earlier, there is a potential cure period for some of these reductions in employment and compensation if you either bring employees back or raise wages to pre-COVID-19 levels. In order to have these amounts cured, it needs to be done no later than June 30, 2020. And then just kind of towards the bottom here is a bullet point we have on here about you will need to submit an application to your lender to receive loan forgiveness. So make sure you're maintaining the appropriate documentation throughout this 8 weeks period so that once it expires, you can apply right away with the lender. They have 60 days under the program to make a decision on loan forgiveness.
Andrew, this is John. Just one last point on that. I've had a couple of bank clients indicate that they may treat these loans similar to a construction loan, such that the proceeds would go into an earmarked account, and then payment would come out when you brought in a bill that hit one of the provisions for which you can get forgiveness under the loan. So whether that's going to be required by SBA or that's going to be on a bank-by-bank basis, I don't know yet. But that's at least what a couple of banks have indicated that they're thinking about on how they're going to police whether they can be in a position to forgive this loan.
Right. Thanks, John. And then lastly on the Paycheck Protection Program is just kind of an overview of, well, what happens when 100% of our loan is not forgiven. It'll be rolled into a typical term loan with terms with a maximum maturity of 10 years and interest rate not to exceed 4%. We've had some clients that have asked kind of about what the interest rate would be. That's going to be more on a bank-by-bank basis, as long as it doesn't exceed the 4%. You're eligible to pay it off early without penalty. And then also an important point is that payment of principal and interest can be deferred from at least 6 months to up to a year after the term loan begins. You're not going to have to necessarily pay this back day one after the loan forgiveness period ends. John or Rebecca, do you guys have any other comments on the Paycheck Protection Program? That's about all I had on that.
Not at this point.
No.
All right.
No, I think that's good. Let's keep moving because we got a lot to cover.
Right. Then we're gonna. Oops. This is just another potential program that the SBA has. This is an existing program, but they have expanded this a little bit in light of the COVID-19 crisis. But they have a program to offer disaster loans to potential small businesses. The eligibility has expanded similarly to how the Paycheck Protection Act expanded eligibility for those loans. And they're kind of also going to be looking at whether or not you have less than 500 employees. Kind of a couple of differences here. This program is going to be, you're going to need to apply through the SBA to receive this disaster loan. You can actually do this now. This program's already up and running through the SBA. You can go to their website to find the application. One additional thing that the CARES Act did is they did provide for this emergency grant of up to $10,000 for loan applicants under this disaster loan program. So if you're in the process of applying it, because it takes probably about 2 to 3 weeks to get the funds, what they can do is give you an emergency grant up to $10,000, which will be distributed within 3 days. This amount can only be used for some limited purposes related to like payroll expenses, similar to the other program. And then other point on that is it's not listed on the slide, but if you get declined for a loan under the disaster loan program, you're not required to repay that advance.
Okay, I'm going to take back credit and give the credit to, or credit. I'm looking at the screen and the title. Hold on. I'm taking back control from Andrew, and I'm going to move to, I think, right, Andrew? The next,
yeah, well, let me cover these next 2 slides real quick, and then we can switch it over to Larry.
Okay, that works too.
And then just 2 other tax-related credits that some potential borrowers or employers may be eligible for. These are really geared towards employers who are not eligible under the Paycheck Protection Program. In certain cases, if you get a loan under the Paycheck Protection Program, you're not eligible to receive these credits. The first credit is a 50% credit applied to payroll tax based on qualified wages paid to employees up to a maximum of $10,000 in qualified wages. So really, you're looking at maximum a $5,000 per employee credit for wages that are paid through the remainder of 2020. In order to be eligible to receive this credit, there's a threshold test that you have to meet, which is basically derived from being adversely impacted by the COVID-19 crisis, and this can come in two forms: whether or not your business has been shut down to a government shutdown order, such as the stay-at-home orders that most states have in place, or if your gross receipts are less than 50% compared to the same quarter in 2019. And then one note on the qualified wages: if you have more than 100 full-time employees, qualified wages only includes wages that are paid to employees while they are not providing services. The same rule does not apply if you have less than 100 full-time employees. And then,
Andrew, can you clarify which employers this applies to? Because I don't think it's clear on the slides. Like, this applies to, there's not a size limit on this, correct?
Correct. If the primary exclusion is if you are receiving a loan under the Paycheck Protection Program, you are not eligible to also receive this tax credit. You can't sort of double dip and get the government to pay your payroll taxes in one instance or payroll costs, and then also take a tax credit. And then lastly, the payroll tax deferrals, the CARES Act provides for the deferral of the employer's share of payroll taxes throughout 2020. How this will be repaid is 50% is due by the end of 2021 and the remainder by the end of 2022. If you are a self-employed individual, you are still eligible for this payroll tax deferral, but you can only defer 50% of the amount that you would normally need to pay. And then also similar to the tax credits, if you're a taxpayer who is receiving loan forgiveness on a loan under the Paycheck Protection Program, you're not eligible to defer your payroll taxes under this program. And Rebecca, go ahead and take back control if you'd like.
Okay, I'm gonna take it back and assign it to Larry. It's like you're doing PowerPoint relay races. So dorky. Yay.
Hi, guys.
Come on, it's my stupid. There's a delay, so Larry, in the meantime, while I'm transferring, just tell me if you need to switch slides, because I don't want to hold up things while I'm trying to look. Okay, you can go ahead whenever.
Okay.
Larry.
All right. Can you guys hear me?
Yes, we can hear you.
All right, fantastic. All right, if you could advance the slide, I think 2 slides for me.
Okay. There you go. You should be able to advance it now yourself.
Oh, thank you very much. Guys, I hope everybody's doing well on the phone and staying safe. As I said, I'm going to cover what's Title IV of the CARES Act, which is known as the Coronavirus Economic Stabilization Act of 2020. What this act does is it really creates two different major lending programs. And for those of you that are following along in the statute, you'll note that I have reversed the order of these. In the statute, it addresses what I refer to as the Treasury programs first and the Federal Reserve programs second. I've done that for a specific reason. the Treasury programs are direct lending programs from the Treasury to businesses in certain industries, specifically air carriers and related businesses, cargo carriers, and businesses that are critical to maintaining national security. I have made the assumption that there are more general businesses out there than there are air carriers on this phone call. So I've switched to none of the Federal Reserve first. Unfortunately, however, for our purposes, there's less guidance out there, and the programs are less well formed for the Federal Reserve than they are for the Treasury program. Late last night, I discovered that the Treasury yesterday released new guidance on the air carrier program. Now, that won't probably directly apply to you, but I'm going to mention it when we get to it because I think it's got some good practical applications for what everybody should be doing now. Okay. Oh my gosh, the slides
advanced. And just to clarify real quick, one of those things, Larry, if I can jump in real quick, is we, because we're designed for time and we want to make sure we address everybody and get the gist of it out there so you leave with this high level understanding, Larry, and we purposely put slides in here with information for you to take along and review later and follow up with questions. So you will get a copy of these PowerPoint slides. If you see Larry skip through something, don't be frustrated. It's mostly because the slide is self-containing and you're going to be free to review it later.
Yeah, the key here on the Federal Reserve programs is that to qualify, you have to be a U.S. business that has not, with between 500 and 10,000 employees, not in bankruptcy and not insolvent. And you can't have had received adequate economic relief from loans or guarantees under one of the other programs like the Payroll Protection Program. I'm sorry, I'm having some technical difficulty advancing the slides.
Larry, why don't I take back over and you can just tell me when to pass?
Thank you very much. I would appreciate that. On the mid-size, one of the programs that the Federal Reserve is going to release is an assistance program for mid-sized businesses. Again, between 500 and 10,000 employees. The key words on this particular slide is that the Secretary shall, quote, endeavor to seek the implementation of a program. I tried to Google endeavor to seek to see if there was any guidance on what that legalese meant, and there was not. But I think it's somewhat aspirational that they're going to prepare this program in the future. What we know about it today, however, is that it's going to be interest rates of not higher than 2%, no principal and interest due for the first 6 months after the loan is made. And here's the key. Unlike the Payroll Protection Program, the principal and interest on this type of loan will not be forgivable. If you could advance. Now, to participate in this program, a business is going to have to make certain good faith certifications in connection with the application. The first two under general matters are really non-events. Again, business, U.S. business, and that current economic conditions made it necessary to get the loan. Seems pretty straightforward. The rest of these, however, I think get into some important issues that you need to consider. I spoke with one company yesterday who, frankly, could use the money of one of these loans, but his exact words to me is, I don't think we want to tie ourselves up right now when we can still get, cheap money other sources. So they may not be looking at this. It's for each business to look at these and decide on a business case basis whether you want to. But I wanted to point out a couple of these. First of all, the funds used have to be used to retain at least 90% of the business. That particular phrase is problematic for me in that they've not clarified what it means to retain at least 90% of the business. Does that mean that you could do a growth program where you will use those employees, or does that money have to be paid out in form of compensation to the employees? We're hopeful that as regulations and more guidance comes out, that the Treasury will clarify, or the Federal Reserve and the Treasury will clarify that. If you could advance. these next ones, there's going to be, for participation in the program, there's going to be restrictions on paying dividends with respect to your common stock during the period while the loan's outstanding, and potentially for an extended period after the loan or the guarantee has been satisfied. And if you're a public company, you're not going to be able to repurchase stock during that time period. With respect to labor matters, and these are important ones for your consideration, you're not going to be able to offshore or outsource jobs during the term of the loan and for 2 years after. Not going to be able to abrogate existing collective bargaining agreements, and you must remain neutral in any union organizing effort. That's been a big deal for some of the people that I've spoken with. If you could advance. The Main Street Lending Program.
One thing I want to add, hold on one second, Larry. One thing I want to add is there's also a lot of confusion because there's so much out there to read and try to stay organized. And one question I get, and I have to clarify a lot, is that union affiliation or union loyalty provision, it has nothing to do with the Paycheck Protection Act. So it's two separate, it's only in regards to this program that Larry's discussing. That's all I wanted to add, Larry.
Thank you. I think that's a good point, and it reminded me of something else that I wanted to add in here. With respect to a lot of things that are out there, including the statute, as I said, there's really two different programs here. One's a direct lending program, and one is where the Federal Reserve will invest money in the financial system, which will then lend to businesses. Be careful as you read the statute. The way it flips back and forth between the two programs, it's a little difficult to tell which provisions apply to which program, and they are different. So you just have to be very careful on the reading on that. The Main Street Lending Program is, at this point, is entirely aspirational. The only thing that's in the act or released from the Federal Reserve yet is that they're going to do something. So we will update on our blog website as new information comes out on this program. If you could advance. Really not going to cover much on this slide, but I did want to put it out here. Under the Treasury programs, now I'm switching gears. I was talking about the Federal Reserve programs. Under the Treasury programs, this is geared toward air carriers and businesses that are critical to maintaining national security. They still have to qualify, with the exception of air carriers, they still have to qualify as an eligible business, or as a U.S. business, rather. If you could advance. What we know today on these loans is that they're going to be for a term of not longer than 5 years. And I think this is a key here. These loans under the Treasury's program are not required to be secured. What the statutory language says is that they must be either sufficiently secured or at a rate that reflects the risk of the loan. So conceivably, you're going to be able to trade interest rate for an unsecured loan. And then the second point that I want to make here is that under the unlike the Payroll Protection Program, these loans are not subject to forgiveness. If you could advance. There's going to be restrictions, strings tied to the money here. There'll be restrictions on the employment levels that you've got to maintain, employment levels as of March 24th, 2020, and in any event, not decreased by more than 10% of such amount. There will also be restrictions on stock repurchases if you are a public company, as well as restrictions on dividends and capital payments. And then under the restrictions for compensation and severance payments, there are really two thresholds here. One is employees who made over $425,000, and employees that made over $3 million. If you could advance. Now, this is an important point, and this again, remember, this is talking about the air carrier program. That program is going to require, similar to, if you recall, TARP program from a couple of years ago.
Can I interrupt? Larry,
yes.
Can I interrupt you? Because I don't think we have many air carriers on. So could I invite them to follow up with you later about this?
Yes,
or get these slides if they have questions? Because we're running close on time, and I have 10 minutes left, and I have stuff to cover too, so I don't want to. Is that okay with you?
Absolutely. Go ahead and advance the slide.
Okay. Anything industry specific, I would rather save to make sure we cover broader categories.
All right. This is, again, and this is the one thing that I told you, this information is new. It came out last night. This is from the Treasury's informal guidance for the air carrier program. What it said is this is the information that people who are going to apply to that program should start compiling this information now. Now, again, we don't have the guidance for the Federal Reserve programs. My suspicion, however, is that the type of information required is going to be similar. Probably not the same. You know, some of this is airline specific, but in terms of things that you should be doing this week, start compiling a list of your debt service, your employment levels. Go through this list. It goes on to the next slide if you want to advance. Start compiling, have somebody start compiling this and putting it together in a folder. Next slide. Okay, there's two things here that are important. First of all, the temporary relief to community banks. I know that there are not, or probably no community banks on here. What I wanted to do is show kind of the magnitude of what the Federal Reserve is doing for banks for the sole purpose of enabling them to turn around and lend to businesses like yours. They've gone a long way, and these, if you were a banker, you'd look at this and go, oh, wow, that's great. But the important point is that the banks are all receptive to having a conversation with you. As John mentioned, we've had talks with a number of our banks already. I had one banker tell me this morning that he's keeping a list of everybody that's called so that when the program terms are released and the application is available, he's going back to his customers in the order that they called him. So if you've not already gotten on your banker's list, I highly recommend that you do so. Some of the things that we're seeing in the market in terms of accommodations, we're seeing fee waivers, deferred terms, loan modifications, and low-rate bridge loans. So I will cut it off there. You have my email. If anybody would like specific information about this, please don't hesitate to reach out. Thank you.
Thank you, Larry. All right, I have 5 minutes left, but if you would indulge me, I would ask for another 10 so I could run a little bit over and make sure you get all the information you need about additional programs. The Families First Act. I put a slide in here just because, you know, don't forget. It's more of a don't forget reminder. We've already done presentations on this. This is last week. This is old news. Pretty funny, huh, that last week is old news. But what I want you to also keep in mind is that, remember, you have these payroll tax credits. So you want to make sure that you're keeping those in mind when you're budgeting paycheck protection loans and everything, because like Andrew pointed out, you can't be double dipping. So you can't, you know, count those, the money you're paying out to pay these paid leaves, the 80 hours of sick, if you're related to the coronavirus, if you have not related, if you have the coronavirus, or if you have, you know, the 2/3 at 12 weeks, all of that, you can't count that as a payroll expense in terms of your forgivable loan because you're already getting the money for that from the government. Now, if you want more information on this, don't despair because you're like, oh my gosh, I wasn't in last week's presentation and I don't know anything about Families First, because you should. So if you don't despair. We have those webinars recorded last week. And yes, there's been additional guidance and clarification since then, but we still have the good basics in those webinars. And if you need access to them and did not attend them, don't hesitate to reach out and we can get you access to those links if they aren't already on our coronavirus task resource, which if you go on the main page of Smith-Amundsen and you see the little, you know, coronavirus symbol and you click on the task resource link, it'll organize all of our constant blog postings by practice group with subject content. So I wanted to make sure you all know that that's available and you don't forget that that's still in play. And it goes into effect actually tomorrow. April 1st was the effective date of that Families First Act. So unemployment, are your employees going to even want to work anymore? I get that question all the time lately because the CARES Act gave an additional $600 a week for up to 39 weeks for individuals with a qualifying reason. Now, it's important to know that this works in conjunction with your state unemployment offerings. So, you know, there are some cases where some of these absences or the inability to work is qualifying for unemployment, state unemployment. In some cases, it's not. The CARES pandemic relief that works with unemployment is triggered even in those events that don't qualify for state unemployment. So if you're an independent contractor and you don't qualify for unemployment, you can still get the $600 a week. If you're sick with, you know, corona or other illness that otherwise renders you unable to work, you can still get the $600 in relief, because remember, unemployment is only available for those people who are otherwise available to work. If you are quarantined, well, I shouldn't say quarantined. If you're at home because, you know, you can't work because a kid's not in school or something along those lines, most state unemployment programs have bent their rules during this time to still consider you available to work because you're available to do a work-at-home job, okay? So what does this mean? This means that if you do qualify for state unemployment and, you know, you're going to get this pandemic relief, in some states that could equal about $1,100 a week. I give the example at the bottom. If you're getting about $400, I think is the max benefit, $100 in dependent allowance, and then you get $600 in pandemic supplement, that could be about $1,100 in weekly benefits. And I think that's important to know. If you have employees that are under, you know, the 52,000 threshold, you know, there's a good chance they're going to be able to get their income continued for 39 weeks through the unemployment process. And I think that's also important for business to understand if they don't qualify for paycheck protection, because then they don't have to feel the weight of salary continuation on their shoulders for employees that make those amounts. The bigger issue I'm going to address with 139 payments is because if you do need to operate because you're essential business, how do you get the people who make less than 52,000 to keep coming into work? You have expanded 401k provisions, and this is important to know as the resource for all your employees. Even if you are continuing operations, you may have employees that are in difficult times right now because maybe their spouse was put out of work, maybe something else happened. So it's important to know that you can take a hardship distribution in your 401k plans, 403b plans, or your IRA. Right now, you can take that up to $100,000 with no 10% excise tax imposed. And you can include those amounts in taxable income over 3 years. Normally, if I took a distribution from my 401k account today, and, you know, I think it's max like 50,000 or something, and I took that, I'd pay the 10% excise tax, plus I'd have it included in my taxable income this year when I filed returns for 2020 in the spring of 2021. This way, I don't have to do that. I can spread that over 3 years. I also have the possibility of repaying the amount. Say I want to take out $100,000 now because, you know, who knows if what the market's going to do tomorrow, and I want to sit on that cash. I can, you know, only pay tax on 33,000 of it and put it back in my account at the end of this year if I wanted. So you're allowed to pay it back. The other thing is available loan amounts are increased. The traditional max of 50,000 is now increased to 100,000 loan amounts, and you can defer existing loan payments, including those of outstanding loans, otherwise due in 2020, up to a year, which means you can re-amortize people with existing loan payments that can provide a lot of relief and give them more in their take-home pay. Because maybe they don't want to be paying back their account right now since the market, you know, is not amazing for these couple months. They also waived the required minimum distributions. If you have somebody who is in that age bracket who's been forced to withdraw funds as a required distribution, they don't have to do that right now if they want to leave their money in there to give it a chance to rebound. Then the important part of this is that you can start operating with these provisions right away. Like you can start today if you wanted. Plan amount amendments are allowed to be retroactive, and you have until 2022 in most cases to implement them. For example, the way it's worded is that the plan year beginning on or after January 1 of 2022, if you make the amendment retroactive and implement it before the end of the plan year, you're fine. So most of us are on a calendar plan year, so that rule translates to December 31st, 2022 is your deadline to memorialize your operations in writing with a plan amendment. And my final point, see, I'm not even going 10 minutes over necessarily yet. There are qualified disaster payments available under Section 139 of the tax code. And being a huge geek about the tax code that I am, I think this is a neat, one of the neatest tools in your toolbox in designing compensation schemes right now and how to deal creatively to get your business through this pandemic. So because President Trump invoked the Stafford Act on March 13th, he triggered eligibility of making payments under 139 of the tax code. And there are only three things. There's not a lot of regulations on 139. There's very little guidance because the provision doesn't often get triggered, and it certainly doesn't get triggered often on a nationwide basis. Right now, it's three things. The payments you make under this program would have to be reasonable and necessary as a result of a qualified disaster. If it's related to Corona, it's an easy thing to do. You could have it assist childcare costs, assist food and lodging expenses, transportation costs. Maybe you want to give people extra money so they don't have to take public transportation to work. A lot of different things. It can't simply be income replacement. You cannot use this to say, okay, we're going to give you an extra sick day and make it tax-free. You also can't use it for expenses that are otherwise reimbursable or covered by insurance. But no documentation is required. You don't have to prove how the employee spent it, and no formal plan document is required. It can be a simple memo saying during this time, we're going to give you an extra $100 stipend for the next 4 weeks. You can certainly do that. The ability to do payments under this program terminates the second there's no longer a declared national disaster under the Stafford Act. So it's use it now or lose your opportunity to do that. And here's why it's key. Payments under this program are tax-free. They are, it's a way to maximize the actual cash dollars going into your employee's pocket. It also the payments they're not subject to payroll taxes or anything else. So, you don't have to count this and pay payroll taxes or anything else on it. There's no additional cost to the business in providing these amounts. And then here's the final kicker. If you had any reservation about whether or not these were a good deal, it's that you can still use the payments made under this program and count them as business expenses in your tax return. So that's a huge thing is that, there's no tax ramifications on the outgoing basis and you get to still claim them as a deduction. I have companies who, before the supplement, we had to lay people off and we weren't sure, if they would ever get a pandemic supplement while the government was sorting things out. We wanted to make sure they could still pay their mortgage and buy food for their family. So, we supplemented unemployment with $300 a week for the next 4 weeks. That went out the door completely tax-free. So the company who was in a financial position and under a cash crunch could afford to do more for their people. So you can do it to former employees, you can do it for current employees, you can do it as a current employee benefit to reward your people for coming in because you need them to come in. And remember, unemployment is a pretty attractive option for some people right now. You want to make sure that they feel rewarded and they're not sitting there mumbling about how the second this is over, they're going to find a new job. So let's see. So we have some commentators who have said they will stay on as long as this goes. But what I want to mention right now is here is our lovely glamour shots. So you all can, see who you're hearing from today with our email addresses and our phone numbers. I want to invite all of our panelists to chime back in and unmute their lines if they have them muted because marketing has sent us a list of questions that if we wanted to take an answer right now, I will try to read them off and we can organize. Oh, actually, I see marketing sent them to all of you. So we can try to take them and go through them for those people who have the time and want to stay on. I do have other engagements starting at 2:30. So I do have a little bit of time here too, if some of you want to continue to answer these questions. I'll start with the first one. It was, if we have an existing line of credit, would that be interpreted as receiving funds for the same purpose? I can say that question to me is ambiguous in terms of, if it's not an SBA loan, that's a different vehicle. I think I mentioned you'd want to take the not unsecured loans over the secured loans. I don't know what existing line of credit you have. Andrew or John or Larry, do you want to chime in anything different in regards to that question?
Yeah, I think what that might be referring to, I mentioned, kind of talking about the double dipping, under the Paycheck Protection Program, if you have received an economic disaster loan under that program from the SBA, you cannot get a loan for the same purpose. So that might be what that question is referring to, but that's limited to a disaster loan through the SBA.
But they can roll that loan into the Paycheck Protection Program, correct?
Correct.
Yeah, the unavailability of credit is not a qualifier, so that, in the inverse of that is that if you have other credit out there, it doesn't disqualify you.
Yeah, which I think is huge. And then,
right.
The next question, a lot of these questions,
the
and I can tell a lot of these questions are going to the same thing, because it's this has got to be too good to be true. For the example, the next question, and I'm reading it out loud for those still on the line. The question is, for necessity of loan, is there a profitability or lack thereof test to determine the loan is necessary, especially for an essential business who's still operational? And the answer is no. It's head count. As Andrew explained, SBA guidelines are looking just at head count and affiliation rules to do that count.
And I think, Rebecca, what helps is to think what they're trying to accomplish here. They're, in one sense, you can say they're not really trying to accomplish an assistance to business. They're trying to get money into the hands of the people. And so that's how I think they've done this, in addition to sending out the checks in the next couple of weeks.
Right, exactly. I've been pointing that out too, John. It's that you are not, as a business, getting free money. It's really your employees that are getting income guaranteed for 2 months.
Exactly.
Or 8 weeks.
Exactly.
And,
so
and
that's
why the forgivability is tied so closely to your payroll levels.
Right.
And Rebecca, one point on that, I think that question might be relating to, I believe I have on one of the slides as part of the certification requirement for an applicant that they are certified as to the necessity of the loan. And with respect to that terminology in that reference, that means necessity of loan based on the uncertainty of the current economic conditions.
Right. That was in the other loans available. Oh, I see what you're saying, Andrew. You're saying maybe that question was geared towards your other loan options that you described. I get it. Do you guys know if the payroll amounts include payroll taxes or just gross payroll? In terms of calculating the available loan amount. I believe that's what the question is directed towards.
Correct. The payroll costs exclude certain taxes, which include payroll.
And those taxes, though, are either relieved if you're doing Families First, because that paid leave gives you payroll tax credits, or else Andrew talked about the Payroll Tax Deferral Program. But I think you said that Payroll Tax Deferral Program is not eligible if you're taking the Payroll Protection Act, correct?
Correct.
It's a lot to keep straight. So don't feel alone if you're struggling with how this all interplays, because we're working really hard to keep a handle on that as well. Let's see here. This is a good question. Must all of the money be used within the next 8 weeks, or can the loan be used for ongoing purposes?
You're directing that at me.
Well, here's the difference. If you don't use it for those specified purposes, it's not going to be forgiven.
Right.
So again, the inverse of that would be you don't have to use them for that, but then it's just a loan.
Right.
And I had someone ask me, like, what if I took more? And my thought was, well, why wouldn't you take more? Because what's the interest on it for how long? And why would you not want to take it over your, if you have personally guaranteed your existing lines of credit, why would you not use this line of credit instead and pay it back? Like, it's still a good deal for a loan.
Right.
Let's see here. I think we answered the question about what interest rates will be charged on this money. See here. How does affiliation apply when there are multiple companies but only one with employees and payroll? Ultimately you're doing affiliation for the head count. So if you have other affiliated companies without payroll, it's not going to matter, right?
Correct. Well, there is one exception to that under the SBA's affiliation rules. There's some informal guidance from them that says when they look at a corporate group, they look at the primary NAIC code. So you have either 500 employees from a head count, or you have the small business size as specified in the SBA rules. So you could have an industry that has a greater than 500 number of employees that are permitted and still be a small business, and they determine that on your primary code. And primary is defined as either employees or receipts. So you could end up with greater than 500 employees in that scenario.
I see what you're saying. He's saying that it could change your NICS code because there are different rules, like the 72 code that Andrew was talking about earlier. If you're in food and lodging, and the SBA has different rules and how they look at you depending on what industry you're in.
That's correct.
Right.
Rebecca, and kind of to that point, I think Larry's going after is the 500 employee threshold that I was discussing earlier. That's really an expansion of the program. If you would otherwise qualify as a small business under SBA guidelines, you can still qualify for the program. It's just this 500 is an expanded eligibility.
Right. Then it says, if an employee, wait, I think I skipped a question. Do you have knowledge of how a number of employees will be viewed if you have a leased employee relationship with a PEO, like a professional employer organization?
And this is subject if the SBA issues different guidelines for this program, but under the SBA's general guidelines, those employees would be included.
So then do they not, do they count for both clients? Because that's dual employment in a lot of other employment arenas.
Right. I believe they would.
Then they'd be double counted.
Potentially.
Hopefully we get some more guidance on that. See here, because there really is very little to no guidance under the 500 head count rule, and we're waiting. We're just explaining to you the traditional SBA rules. There's nothing out yet. And so I imagine they have to give more guidance on that, because a lot of our questions are going towards how do you count the 500. And so all we have right now that, John and Larry and Andrew are going off of is traditional SBA rules. And so many of that disqualifies a lot of, or in some cases, that's why we have some clients who just disregarded the first glance of these benefits because they thought, we don't qualify for SBA. So I don't think the intent is to, disqualify a lot of business. So it'll be interesting to see what clarification they come out with. And I think you want to, move forward and at least start getting your information together, even if you might be disqualified for that reason, because, if there's a big line growing and people lined up to get this money, you don't want to be getting in the line late, if that makes sense.
Well, and Rebecca, you also want to talk to your banker, even if you get one of these loans. I think you also, when you sit down with your banker, need to talk to them about deferring payment on your existing debt, because most banks are going to do 3 to 6 months deferral and either push your maturity date out by 3 to 6 months or put a balloon at the end of it, one of those two. but you might as well have that same conversation at the same time so they get a complete picture of your financial situation, because the last thing bankers like is getting a surprise.
Yeah. Okay. If an employee / owner, and I've gotten this question emailed to me in a different way, I guess, about the 100,000 limit on employee comp. If the employee owner has a salary near the wage limit of 104,000, and voluntarily reduces that to 100,000, will the revised salary for that employee qualify for the Paycheck Protection Act program? I think I want to clarify to an extent that it's not that if you make 104,000 that your entire salary is disregarded. It's just that the first 100,000 is counted as a permissible expense. Is that how you guys understand it?
Correct.
Yes, it is.
Yes.
So I don't think there's any reason to cut your own salary by
I
$4,000 a
no.
year.
No, I wouldn't do that. It's just going to cut you back to 100,000 in terms of calculating how much you can borrow.
Right, because you calculate total comp for availability, and then only 100,000 in terms of permissible expenses that you use the loan proceeds for. So I think that's important to know. We talked about tax credits available for companies outside of taking a loan, payroll taxes and all of that stuff. Oh, here's a question. Are bonuses and incentive pay included in payroll comp? My understanding is yes. Do you guys understand that differently?
I have heard both sides on that one, and I'm waiting for SBA guidance on that.
I could see how you've heard both sides, especially if it's in excess of 100,000 and stuff like that. But yeah, so I guess that is a John. You got the negative banker attitude. Okay, group health care.
Well, that may
costs,
be wrong. We'll have to see.
I know. Group health care costs. Well, no, I mean, you're still going to be subject to the 100,000 comp, so it's not like bonuses are a separate factor.
Right. Right.
Group health care costs are listed under included costs for the Paycheck Protection Program. Is this only medical, or does this include dental, vision, et cetera? And is this both employer and employee portion of premiums? My understanding is yes and yes, but please feel free to disagree with me. On rare occasions, I am wrong.
I think you're right, as much as it kills me to say that.
Okay, good. Are the tax credits under Families First different than the employee retention tax credit? Yes. It's two separate things. So you gotta, be buddies with your accountant, or be super nice to your CFOs or whoever's doing your numbers, because you want to make sure you figure out, what is the best method for you to utilize. I mean, obviously, if you're under Families First, you have to do that. You have to provide that leave. It's not an option. So you need to understand the implication of that on your taxes to decide if you have anything else available that you can utilize, because like Andrew pointed out more than once, you can't double dip. And I think that's all of the questions. So,
all right. Well, thank you everyone for joining. I believe we've had more than 100 questions submitted. We've tried to group them in to answer them in groups. Apologize if we didn't get to your specific one. We will email to you later today all of the slides for this presentation. If you have additional questions, if they didn't get answered in this Q&A, please reach out to one of the four of us, and we'll walk you through the process and get your answers. So thank you all for doing this. I think we're done. Bye-bye.
Take care, everyone. Bye.
Bye-bye.